Hi, this is Eric Olson, Director of Helps. This email is being sent to new clients of Helps who we've identified as having a credit union bank account. They bank with the credit union. And I just want to talk to you about credit union bank accounts. They're a little bit different, and we have some concerns at Helps sometimes that we need to make people aware of. So, a lot I can talk about credit union bank accounts. Credit unions are different than banks. Credit unions are very popular with people for a lot of different reasons. But there's some difficulties with credit unions, and that's why I'm doing this video. So if you have a credit union account and you don't owe the credit union any money, great, okay, so far. Now, if you get sued and someone sues you and gets a judgment, and then they were to garnish your credit union account, that's what I want to talk about. There's a federal law that's been in effect since 2012 that protects automatically banks and credit unions are instructed to automatically protect twice the amount of federal benefits that are deposited into a bank account from garnishment, regardless of what monies are in there. Now, what do I mean by federal monies? Social Security, federal pension, post office, VA benefits. But let's say you get $1,500 in Social Security and it's deposited in your credit union. Okay, and the same goes for banks. Twice that amount is automatically protected under this federal banking regulation from garnishment. And the way it works is a department in the bank or credit union, if they get a garnishment, the garnishment goes to this department, and then they can identify the source of the funds that went into your account. And if it was federal funds, all they need to do is times that times two, what amount you get each month. And then that amount is protected regardless of any funds, what funds are happen to be in the account at that present time of the garnishment. Okay, that's the way the law works and it's supposed to work. And I used to tell people, I still do, probably 999 out of 1,000 attorneys don't understand that rule. Okay, even though it's been in effect for 12 years. I haven't talked to a bank manager yet that understands that rule. Okay, I don't talk to too many credit union managers, but I haven't talked to a bank manager yet that understands that rule, but the department in the bank understands the rule. So why am I talking to you about a credit union? Well, okay. We deal with thousands, tens of thousands of seniors throughout the United States. I tell people that if you've got 10 creditors that you don't pay, maybe 1.5 out of 10 would sue you. You may never get sued, but you might. More than one might sue you, okay? And they get a judgment. And we tell people they can't take your Social Security, they can't take your pension, and we explain this rule on how your bank account or your credit union account is protected. Well, because we have so many clients, we talk to clients every day that are being sued just because creditors decide to sue them for whatever reason, even though they may have gotten a letter from Help saying this person's income is protected. It's a waste of your money to do it. I think a computer makes the decision. So if the client gets sued, they notify us, we send a letter to the attorney, tell them, hey, the person's income's protected, don't bother them anymore. We expect that they're going to get a judgment, and we tell them don't touch their bank account. They can't anyway for the reason I just told you. And then we contact our client and assure them they don't need to worry, they don't need to go to court, but judgment proof. And we explain how their bank account's protected. Well, it's not a perfect world. And because we have talked to so many people that are being sued, not because of they're likely to sue, just because we talk to a lot of people. If there's ever a problem with a bank not following that rule, it's been in effect now for over 10 years. It's almost always with a bank, with a credit union. Okay. Personally, I don't think it happens that much with credit unions, but one of my attorneys thinks that it happens a lot more often than, and she deals with the credit unions on this issue, so she knows, deals with it a lot more often than I think it happens. And so she persuaded me that, maybe we should do a video and let clients know about this, because it can be a headache. It can be a headache. So the way the rule reads is that if the credit union gets a writ of garnishment, they have 48 hours to examine the account to determine if it came from a federal source. And with banks, they usually do with a matter of a few minutes. So they look at it, take twice the amount of your federal benefit that you get in your bank account, boom, they release the money. It's not tied up. But if a credit union doesn't understand the rule and doesn't follow it, then they're gonna hold on to that money. They're gonna put a stop, and your client's gonna call us and they're gonna say, "Hey, Eric, I thought you said our money was protected in our credit." It is. I can't protect people from, prevent someone from mugging someone or from committing theft or stealing. And essentially, that's what a credit union does when they don't follow the law. If they don't follow the law and they say, "Well, we got to pay this," then, we want our client to contact us, which contact the credit union. We've got emails that detail it. We have to educate them about it. In fact, sometimes I've talked to the credit union attorney, say, "Here's the law. Why don't you educate your credit union what the law is so we don't have this problem?" How many times has it happened that your credit union has paid money to a creditor when they weren't supposed to? So it can get frustrating. And then sometimes the credit union might ignore us. But the problem with the client is they need the money now. Our clients usually don't have a lot of income, and this is their only source of income. And if it gets tied up by the credit union not releasing it immediately like they're supposed to, it can be a real headache. So for that reason, you might want to consider, changing to a bank instead of a credit union. Now, you may not need to worry about that unless you're sued, and then you could do it then. Or you may want to say, "Well, Eric says this is unlikely going to happen. If it has, they can help me undo it," which we can. But part of the problem is the law doesn't have a process for us to sue the bank or credit union, or for some to sue them for making this mistake. So if we got a credit union that just chooses to take it personally that we're trying to tell them that what they're doing is wrong, they might just forget it and not make it right. And we've had that happen. And what can we do? You go to a local attorney, you're not going to sue for $500. And how you do it? How do you sue the credit union? So, maybe someday we'll get some legislation that will be able to put some teeth into the law. So that's the scoop on credit unions. Take it for what it's worth. I don't want to offend any credit union. Most of them do it right, but there appears to be a significant percentage of them that do it wrong, that I have to make this video. Now, let me talk about a couple other things about credit unions too. Just so you know, if you've got a car loan with your credit union and a credit card with your credit union, credit unions have what's called cross-collateralization agreements, which means if you got a car loan and got a credit card, that credit card agreement that you signed says, by the way, if you have any other loan that's with this our credit union that's secured, has security, this loan also secures that loan. So what that means is If you're buying a car from the credit union, let's say you owe 10,000 on the car and it's worth 8,000, and you want to keep the car, fine. But let's say you got a $10,000 credit card. Well, if you don't pay the credit card, it's unlikely the credit union's position is, hey, you don't owe 10,000 on that car, you owe 20,000. You owe 10,000 on the loan for the car, plus you owe 10,000 on that credit card, because that agreement, that's the way their agreements work. Banks don't use those forms, credit unions do. Now, if you don't pay the credit card, unlikely the credit union would come to repossess the car, as long as you make the regular car payment. But try to get a title after the car's paid off. They're not going to give it to you until you pay the credit card debt. Now, why don't they repossess the car ahead of time? Well, we've got some internal letters from attorneys that advise credit unions saying it could be a tricky situation, so we don't see that happening. So the bottom line is, if you've got a car and you got a credit card debt with the same car financed by a credit union, and they owe another loan to the credit union, they're not going to give you the title until that loan is paid off. Now, if you're current on that other loan and you paid off the car, then they'll give you the title. But if they suspect you're not going to pay it, or if it's in default, they're not going to give you the title until that other loan is dealt with. So that leads to a whole lot of other issues. If you want to bank at your credit union and you choose not to make a payment on a loan you owe to them, the credit union will eventually just kick you out of the credit union. That's why we tell people, you got a credit union with a loan that you're not going to pay, go to a bank, go to someone else, because the credit union is not going to allow you to be a member if you owe them money and you're not paying them. I suppose there could be an exception, but they're few and far between. Now, banks aren't the same way. If you have a bank account with a major bank and you don't pay their credit card debt or the loan debt, and you have a checking account with them, they're not going to kick you out of the bank. Now, the rule of the bank, there's a rule that's called offset, okay, with Social Security. And that's a federal rule that tells banks and credit unions that they cannot offset money from your bank account to pay a loan that you owe the bank if the money in there is from Social Security. But what they can do is they can offset, either a bank or credit union can offset money in your bank account if you've got an NSF check or you have a bank fee that you owe. But they can't offset money in your account from Social Security to pay a loan. Credit unions, an exception. Whether you know it or not, you signed a piece of paper when you made that account with them that gave them a specific authority to take money out of that account. And they'll take it out of your account to pay a, even if it's credit, Social Security in the account to pay the loan. Now, they're not going to do it right away. You're going to have to be behind quite a bit before they do it. So if you're not going to pay the credit union, you want to go to a different bank. Get a different bank institution. And if you're worried about it, someone suing you and you're possibly losing the money because they don't follow that federal rule, it's been in effect for 10 years, and get a different bank account. You don't need to do it now. You don't need to do it right away. You might want to wait till see if you ever get sued and then do it then. Or you might want to take your odds and say, well, it's unlikely it's going to happen. And I would still say that it's unlikely, but it happens often enough that that I'm making this video. Okay. And it's funny, even the organization that governs credit unions doesn't understand this rule. Maybe we've written them, given them the explanation. They don't understand. I don't know, maybe got a bunch of law students that don't know the law. Okay. Now, banks know it. Credit unions don't. This is another where a problem can crop up. If you owe taxes, I'm not talking about IRS. If you owe IRS taxes and you're a new member of HELPS and you're lower income, we can get you on, or you can get on what's currently not collectible status, where you don't have to pay the tax. But where the problem come up is state income taxes. Okay. the money in your bank account from Social Security is protected from a state tax collector garnishing your bank account, just like a regular creditor would garnish your bank account. So if you live in a state and they try to garnish your bank account, the bank is, if it's less than twice the amount of your federal benefit, even if it's a state tax collector, the bank is supposed to disregard the garnishment. Now, when this first law first came into effect, there was some questions about that for a while, but within a year, the federal regulators clarified that in writing and told the banks, hey, the rule is the federal benefits are protected even from debts owed to the state, including state revenue departments. Now, the only exception to this rule is if you owe child support, but we're not talking about that. We're talking if you owe the state a fee or you owe them for taxes, your Social Security, twice the amount, is protected. But once again, once in a while, we've seen a state garnish a credit union, and the credit union might think, well, this money is protected from credit card judgments, but not from the state tax collector. We got to pay it. So we go to the credit union and we show them chapter and verse, and we might get the cold shoulder. Sometimes I think, credit unions, they're kind of easily offended, maybe. They're maybe not as professional in some ways as banks are. There's a reason for that. And I know what I'm talking about because I've been doing this for 42 years, bankruptcy, before I started HELPS. And I've been running headaches from credit unions from the word go. Once again, not always, it's the exception. But, the exception is the headache. It's a headache for the client where it happens to. It's a headache for us trying to undo it. Okay? So, kind of rattled off on this email or this video. And I've said my piece. I want to welcome you to HELPS. Don't assume that there's going to be a lot of problems and you're going to have to worry, because you're not. Okay? But we're sending you this email because you have a credit union account. I want to make sure you understand all this stuff. The whole purpose of HELPS is if you're worried or scared, you pick up the phone and you call us. Okay? Your income's protected. Your assets are safe, as we've discussed. And we don't want you to worry. And we're going to want to stop the creditors from bothering you. So welcome to HELPS. And you're going to be fine. Take this into account when I've talked about credit unions, and you can make a decision. It's not the end of the world to close your credit union down and open up a new bank account. It's not. And you may decide you don't even want a bank account. You can get your Social Security loaded on what's called a Direct Express card. You don't even need to have a bank account. And if you want more information on that, call HELPS. We'll send you an email that tells you about that. Okay, that's it. You guys have a great day. Welcome to HELPS. Call us if you have any questions.